Thank you for viewing the third in our three-part series of What to Do When a Loved One Dies. As I have indicated previously in our presentations, this series grew out of our experience in counseling probate clients for many years, and we have observed that people are often at a loss for what to do because they are being called upon to handle the affairs of someone who had meaning in their lives, and at the same time, they now must handle the business and legal affairs developed during that person's lifetime. Though this series is not an in-depth presentation on this subject matter, it is meant to provide an outline so that you, as the person designated to do these things, will have some sense of direction as to where you need to go next. Our job is to support you in properly handling the affairs of that deceased person so that you can feel good about the job that you've done in bringing honor to the life of the person that you cared about. My name is William Hayes, and I have been practicing in the field of probate law for approximately 30 years. On the screen, you will see a brief statement of my legal and academic background. Our law firm has been located for over 22 years in the beautiful and historic Behringer Studios building. Our office has been cited by many of the major media as a source of information on estate planning matters, and we have consistently received high ratings on most of the social media. Probate. What is probate? Well, probate is a legal process that takes place after someone dies. The estate must go through probate if the estate's dollar amount exceeds a certain amount. Probate in such instances is required whether the deceased person had a will or had no will at all. The process of probate can be avoided if the person had a trust. During a probate, you must identify and compile the deceased person's property, have it appraised, pay the debts and taxes, and distribute the property to their heirs. As previously mentioned, this presentation is not meant to make you an expert in the field of probate. It is meant to give you an understanding of the essential elements that you will have to deal with during the process. When you are the administrator/executor of a probate estate, there are certain steps in the process that you must follow. By the way, when I use the word administrator, it will apply to people who are in charge of an estate where there is no will. And the word executor is used in a situation where there is a will. The first step in beginning the probate court process is to file a petition for probate. At the same time that you file the petition, you will want to begin the process of publishing notice of the petition for probate in a local newspaper. The third step in the process will be to obtain a court hearing date for the petition to be validated by a judge. And if your petition is approved, the court will give you a ruling to that effect, and then an order must be prepared for the judge's signature. Once the order is signed by the judge, you will then be issued letters of administration. After you are appointed the administrator/executor, you may want to have a probate referee assigned to your case. Another function of the administrator/executor is to determine which of the deceased person's creditors should or should not be paid. When all of these matters have been handled properly, you will then be in a position to file a final petition for the accounting of the estate and the distribution of its assets to the beneficiaries and creditors of the deceased person. The probate court process is not a quick process. These days, it can take anywhere from 6 to 12 months to administer even the simplest of probate estates, and in some cases, it can take years to conclude a probate estate. As previously mentioned, the first step in the process is to file a petition for probate. Among other things, this will require that you put together all of the information needed for the petition for probate, such as the date of death of the deceased person, their address, whether they were married, who their children are, what their addresses are, whether they have real estate, and what the approximate value of the estate is. Pardon me. Throughout this presentation, I want to point out important facts that you may wish to know. For instance, did you know that you do not have to pay an attorney up front to begin the probate at the estate, and that the attorney will not expect you to pay the attorney's fees personally? The next step in the process will require that you find an appropriate local newspaper in which to publish notice of the petition for probate. Another important fact for you to know is that the primary expenditures for the completion of the probate court process will require that you pay fees for the following: the filing of the probate petition, the publication of the petition notice in the newspaper. You may have to pay for a probate referee, which is basically the person who appraises the estate property. And unless it is waived, a bond may be required. And the final payment that you will be expected to pay is for the filing of the final petition for the accounting and distribution of the estate. You will have to make an appearance in court after the petition for probate is filed to determine whether the petition meets all of the requirements that the court requires. If the petition is approved, you will have to prepare an order for the judge's signature appointing you as the administrator/executor of the estate. It is important for you to know that if you are the administrator of a probate estate, that you can hire an attorney to handle most of the work, and you will still be paid your full fee as the administrator of the estate. After the court approves your petition for probate, you must then prepare and file for letters of administration, which have to be signed by the judge. As the administrator/executor, you are entitled to be paid the same statutory fee as the attorney. A primary function of the administrator/executor is to accept or reject the claims of any creditors who assert that they are entitled to be paid money from the estate. It may be necessary to appoint a probate referee. A probate referee's primary function is to appraise certain assets of the estate. As the administrator of the estate, you are also entitled to be paid for various other services to the estate that the court believes are outside of the normal course of a probate administration. After you have determined all of the assets of the estate and had them appraised, and you have determined which of the creditors are entitled to be paid, you are now in a position to prepare and file the final petition for the accounting and distribution of the estate's assets. There are many reasons why most people who file petitions for probate hire an attorney. It's important to hire an attorney because an experienced attorney can significantly help to accelerate the administration process and shorten the timeline for the completion of the administration. Secondly, most of the work involved in the probate process will be handled by the attorney, thereby relieving you from most of the stress and uncertainty of working in an unfamiliar field. Third, an experienced probate attorney will be well versed in the laws, rules, and regulations that are a part of the probate court process. And an attorney can help you effectively manage the assets of the trust to minimize the potential for complaints or lawsuits brought by unhappy heirs and creditors. And finally, the attorney will ensure that you are not exposed to legal liability due to your failure to perform or avoid certain actions. So if you have a probate estate and that you are administering or about to administer, please make sure that you do so in a timely manner. If you intend to be appointed the administrator executor of a probate estate, don't delay and don't hesitate to call us for free, no obligation phone consultation so that you will have some direction as to what you need to do next. Thank you very much for having taken the time to view our presentation, and please let us know if we can be of help to you. Thank you.